Good afternoon, everyone. Good morning to those of you on the West Coast. This is Josh Willie, and on behalf of PCI, I'd like to welcome you all to today's session of GovCon 101 covering Flowdowns, joined by our expert instructor, David Gallacher from Kudak Rock. Before we begin, I do have a few housekeeping announcements. Those of you new to our GovCon 101 programs and seeking credit, please make sure you are tuned in, listening closely. We will not have passwords for this session, but we will have polling questions at the very end, which you will need to participate in if you are seeking credit. In addition to polling questions, you are more than welcome to submit any questions you have throughout the session. You can send your questions through the questions tab located at the top right of your GoToWebinar window. It is a little question box, and you can submit any questions, comments, anything you'd like to communicate through there. If you guys have any technical difficulties, please don't hesitate to let me know. We will take questions throughout the session, but we will not answer any questions until the end. With that, I thank you all so very much for joining, and I will hand it over to David.
Thank you so much, Joshua. I appreciate it. Everyone, my name is David Gallacher, and I am an attorney with the law firm Kudak Rock in Washington, D.C., and we're here today to talk about flowdowns. Everybody's favorite topic, flowdowns. Well, let's walk through it a little bit. As I mentioned, I'm an attorney in Washington, D.C., and I've been practicing for about 20, almost 25 years now, and I do nuts and bolts government contracting law, just about anything relating to the FAR or DFARS. I've touched it, handled it in some way, shape, or form. I do a lot of litigation associated with like bid protest claims, False Claims Act defense. I also do a fair bit of client counseling where people are just, they pick up the phone, they give me a call, and they say, Dave, we need a little bit of help with this. There's a new rule in the FAR. There's a new executive order. What do we do associated with that? So that's about half and half of my practice. So happy to be here with you today talking about flowdowns. One of my specialties is relating to supply chain management. What do we do to help make sure that we're sourcing from the proper locations? That's Buy American, Trade Agreements Act, country of origin issues. It also has to do with prohibited sources like the anti-Huawei or the TikTok ban as we deal with some of those things. And we'll touch on some of these as they come up, but also an awful lot relating to subcontract management. And I do a 9-part series here for PCI and subcontract management. And this flowdowns is just really, it dovetails very nicely with that as we talk through that. Because in truth, when you're a prime contractor and you need to award a subcontract, you have lots of terms and conditions that you need to include. The question is, how many and which ones? So we're going to talk through that a little bit here. Reminder again that we're going to have 5 polling questions coming up here at the end that are designed to kind of capture the knowledge and ask questions associated with what I'm talking about through this first hour. So I look forward to your participation in that, and then we'll take questions at the end. But with that being said, I got an email earlier on from Cynthia indicating she had some very specific questions. And so, Cynthia, I want you to know I'm going to talk about the answers to your questions here as we go through the entire series, and then I'm going to recap as we come back on it just to make sure that I answer those questions here for you, because they are good universal questions that I'm sure more people than just Cynthia have. So thank you so much, and it's great to be here with you. But again, I want to emphasize questions are certainly welcome. I would love to talk through what you're actually interested in or what's actually bothering you when it comes to contract flowdowns, as opposed to me trying to read your mind, which doesn't usually work well for me. So we'll deal with those answers to the questions at the end here. All right, so let's walk through the agenda here. I want to start with a few general principles when it comes to flowdowns. I want to talk a little bit about this world that we live in, because typically speaking, the people that are worried about flow downs are either prime contractors flowing down to a sub, or a subcontractor dealing with whatever it is that the prime has pushed down to them, and they're trying to push this down through the supply chain. And really, the question of flow downs often becomes a question of risk management. We are trying to manage the risk associated with contract performance, make sure we can deliver to our customer, and make sure that our suppliers are meeting us in the middle. So that's an important conceptual point in this, because that, I think, guides a lot of the practical application of what flow downs look like, because there's no single best answer. I want to talk a little bit about this idea of self-deleting that commonly comes up in the context of flow downs, and then also this principle about the Christian doctrine, what that is and how it applies at both the prime contract level and how it's a little bit different at the subcontract level. After that, I want to dig in and talk about flow downs. I want to talk about the mandatory flow downs. This is a list of 20 plus clauses that are typically going to be on your must list. You're going to find these in probably just about every type of subcontract, commercial, non-commercial, and otherwise. And then we'll also talk a little bit about necessary flow downs that are maybe not necessarily spelled out as you must flow this down in the individual contract. But as a practical matter, if you're a prime or if you're a sub flowing this down into the supply chain, you might need to do that. And so we'll explore what some of these necessary flow downs are. And then, of course, a ubiquitous other category of other types of flow downs. And I'll explain what we mean when we get there. And then we'll do the questions and answers and respond to your specific points. So keep those fingers warm and feel free to type anything in as it comes up. First, risk management in government contracts. We all know that the federal government loves writing long contracts. And part of the reason for this is not just because they hate us, right? They don't. It's just there's a lot of policies that come into play that Congress or agencies or the White House say, this is something that we want to accomplish. And so they use the power of the purse to extract these policy goals. You see this a lot lately playing out through a lot of the environmental and environmental issues relating to purchasing sustainable products and disclosing, how companies are doing on this. This is the government saying that's a policy we want to encourage, and so we're going to build that into the contract. 9 times out of 10, a lot of these things actually don't have anything at all to do with your actual contract performance. But nonetheless, it's in the contract. So when it's in your contract, it's something you need to be thinking about in that. And what that does as a practical matter is it makes these government contracts very, very long and thick with lots and lots of different requirements. Now, we would love to kind of push back on that and say, redline all this out. We don't need that. But when it comes to dealing with the federal government, well, as Mel Brooks says, it's good to be the king, right? They get to set the terms, and we get to respond on it. And the negotiation balance between private companies and the United States government is not really balanced. Typically speaking, you take exactly what the government tells you, and your opportunity to negotiate down those clauses are usually very limited. Okay, now by comparison, though, once the government flows down its big long list, the prime contractor's goal is saying, okay, now what I need to do is manage my risk here so that I can best perform to my government's expectations. And what that typically manifests as is I need to make sure I understand what my technical requirements are so I can flow that through. I need to understand what my legal requirements are, contractual requirements, so I can flow that through. I need to understand what personnel requirements I have so I can flow that through. And making sure that at the end of the day, the relevant parts of whatever scope of work the subcontractor is going to be performing, that I've accurately translated what it is that my prime contract requires, and I put that into my subcontract. And this is typically, it's a risk mitigation function here, because the prime contractor wants to make sure that if it's using you, subcontractor, that sub and prime working together can deliver what it is that the government customer needs. So, but it gets complicated because sometimes these prime contracts that the government writes are very, very complicated, whether we like it or not. Now, importantly, as you go through this, I mentioned technical requirements, right? If I'm providing a particular widget on let's say a DoD program, then my technical requirements are probably not going to be that entire statement of work, but just a segment of it, right? And so that gets flowed through to me. But it's beyond that, beyond technical, there's also these legal requirements, many of which are in the prime contract, that say this must be flowed down. Okay, and so importantly, at risk of breaching the contract with the prime contractor, you've agreed when you took the prime contract to flow this down. You need to make sure you understand what those clauses are. And then, as I mentioned, as a second practical matter, you need to understand also what's necessary so that this subcontractor or supplier can perform for the government customer. So there's a little bit of tension in that, and it also sometimes puts the prime contractor in the middle of this ham sandwich as it's trying to figure out, okay, how do I meet my customer's needs, and how do I award a functional, workable subcontract? And what you typically find here, spoiler alert, and we all know this if you're in the industry, right, is you have the prime contractor that is usually flowing down just a whole lot of stuff. So sometimes you have government contracts here that this is from a solicitation that I recently worked with. And this is just 5 pages that lists about 180 different FAR and DFARS clauses. Now, it was a non-commercial contract. It had services. It was cost reimbursable. So all of these things make it a little bit more complicated and a little bit more likely that it's going to be regulated. But nonetheless, these are 5 pages out of 142 pages in this solicitation here that impose a whole lot of requirements on the prime contractor. And guess what? Prime contractor is probably going to want to be very, very cautious. And unsurprisingly, they're probably going to try to flow down every single one of these things. Maybe listing them, maybe attaching this whole thing as an attachment. Maybe, I see this sometimes, the prime contractor says we're attaching as Exhibit 1 to the subcontract our prime contract, and you, subcontractor, agree to be bound to our prime contract obligations to the same extent that the prime contractor is. It's a little bit of a blunt tool. Maybe it's a little sloppy. Maybe it's a little bit lazy. I always like it when we can kind of cut through a little bit more and not be flowing down pages and pages of extraneous information. But nonetheless, it's a very real problem that we're constantly dealing with as we're trying to figure out what do we do with these 180 different contract clauses that are in this contract here, and that we're trying to, well, figure out how do we apply them, how do we flow things down, and what do we actually need to meet. Now, typically, the way that this manifests and the way that companies do this is they will either flow down by reference or by full text incorporation. So what do I mean by reference? Well, by reference, I mean that you list a specific clause by number usually, and often you see the title for it, and sometimes you have the date, sometimes you don't. If you have that in your subcontract, that's one way to get these things in. Sometimes I see people attaching it and saying, see Exhibit A, and it's say these 5 pages, right? And that may very well get you there too, because it's incorporating these things by reference. But the important point to remember is you need to make sure you are referencing it in your subcontract as a flow down if it's going to apply. If you do not mention it, it's probably not going to apply. And we'll talk about that in a little bit as to how that, as a practical matter, plays out. And it's one of the reasons, that risk issue of I need to make sure I mention it in order to make sure that it flows down and make sure that my supplier or subcontractor is bound by this term. The fear is that, well, what if I miss something? What if I miss this particular clause, 252, 227-7037? Right? And so we run into a world here where people are constantly flowing down a lot more than is necessary. And I understand why people do that. Again, my hope is that we can maybe step back a little bit here and just flow down what we need to as a practical matter to accomplish the contract objectives. Okay, so that's incorporating by reference. The other common way that I see in terms of flowing these things down is incorporating by full text. And you see this here at the bottom of this page where it spells out the 52204-27 prohibition on a bite dance covered application. This is one of the newest updates to the FAR over the last few months, June 2023, that basically prohibits TikTok on devices that are being used to perform government contracts there. And yes, this clause actually is listed up on those other 4 pages that we saw here, but for whatever reason, in putting the solicitation together, they also spelled it out in full there with the specific words, cutting and pasting it out of the FAR. What's the difference between the two? Functionally, I don't really think that there is a difference, as long as it's incorporated and dragged in some way, shape, or form. I will tell you that if on each of these 180 clauses, you're spelling them out in detail, you're going to have like a 3,000-page contract. And that's not helpful for anybody. I mean, look, it is helpful because you know exactly what that contract includes, right? You don't have to go hunting for outside sources. But the problem is it's a 3,000-page contract. So typically what I see is usually it's this incorporation by reference. Occasionally some of these full text spelling out a particular clause, although easily by far it's normally by reference. Now, I want you all to be mindful of the undated problem. What if I merely go through and incorporate 52204-27 by reference, and I don't spell out the full text, and I also don't include a date on the clause? As you see, this clause here is dated June 2023. But what if I just incorporate it by reference? Or put another way here, what if I incorporate 52244-6 versus 52244-6 dated February 2024? What does that mean? And I see this a lot because there's a lot of times companies that just spell out a specific clause, and they will sometimes also say this clause will automatically update as it's updated in the FAR, which is a little obnoxious, right? Because our contracts are supposed to be defined contractual documents that we're able to price and we're able to define our obligations on, and then to have some kind of a live tumor, if you will, that's growing and that can evolve on top of this, where the terms may very well change. That's very problematic. I see it all the time. I see companies sign up to it all the time. Nonetheless, I do think that is definitely a reach, and I think that the more typical way, and this is the way the government does it, is they spell out a specific clause and they give you the specific date version on it. Now, if you don't have a date, generally speaking, what the case law is, and I think this is where most people land, is it's whatever clause was in effect as of that date. So if I've agreed to 52244-6, and I signed my contract here on May 13, then it's probably whatever version of that clause was in effect on May 13th. The idea that later some kind of June or July or August version of that clause is necessarily going to be drawn in is probably a bridge too far. Now, like I said, I sometimes see these contracts that say that the references will automatically refresh as these are updated. And again, even though I think that's a little bit of a reach and it might be a little obnoxious, I've had my clients do that, and I understand why they do it, because they're trying to manage the risk. And I think certainly in the government contracting space, there's a little bit of an understanding that we're all kind of constantly monitoring this. Nonetheless, if you don't put a date on the clause, you should not necessarily automatically assume that that is kind of an ever refreshing version of the clause. In truth, it's probably whatever version of the clause existed as of the date that you signed your contract. So that's just a little bit. I've got another slide on this later on, but this is a common problem that I see companies do. As you create templates, especially relating to Flowdowns, you don't want to be constantly tinkering with that when they issue a new FAR rule tomorrow and then another FAR rule 3 weeks after that, right? You want to have one template that you're looking at and refreshing on a regular basis. And so isolating yourself to just some of these specific dated clauses can sometimes feel very limiting. I think many companies will often just say, I've got 52244-6, and they're going to deal with the reality of whichever version of that clause to the extent the dispute eventually comes out of it. So, okay, so that's way number one is you incorporate it by reference. Second is you incorporate by full text, and there you go. Now, I'll get into the list of the clauses that we must flow down. Remember, these are what I'm calling the mandatory flow downs. I'll get into some lists of some contracts that are maybe needed, that are maybe necessary flow downs. These are notional ideas that Dave Gallacher is using this of mandatory, necessary. In truth, it's going to be spelled out in your specific contract, but I'm going to try to guide you through what some of these lists of clauses are. It's important, though, to realize that some clauses specify that they should be flowed down without alteration, meaning I've got my prime contract that says XYZ, and it says, David, you must flow down that exact same clause. You don't get to tailor it to adjust for whatever my business objectives are, except for you flow it down and you maybe adjust the names of the specific people on this. And a perfect example of that are the data rights clauses and the computer software clauses from the DFARS. These specifically say, prime contractor, when you flow this clause down, you must flow it down as is, adjusting only the names of the various parties. So it's important to realize that some clauses, to the extent you're flowing them down, must be flowed down specifically. And the reason being on this data rights and the computer software was the government was really concerned over the last couple decades that prime contractors were maybe chiseling out a little bit more on the edges. The government only needed this much, but out of an abundance of caution, the prime contractor was trying to get more. That was extra cost to the government. It was maybe a little manipulative of the prime, not necessarily maliciously, but they were using the government's needs to try to extract more rights than were necessary. And so the government in these DFARS clauses have basically said, no, whatever the government needs at the prime contract per these DFARS clauses, that's exactly what you're getting down through the supply chain. And the clauses say you must flow these down without alteration. Another variation on this is FAR 3.503-1 that provides limitations on a subcontractor's right to sell directly to the government. The government reserves the right at the end of the day, if they don't like what I, prime contractor, am doing, they could cut around me and go directly to my supplier. So to the extent I have some kind of a limitation that says you can't sell, supplier, directly to the government, that's not going to fly. The government, again, it's good to be the king. They set the rules here, and they reserve the right. If they can cut me out as a middleman and save a little bit of price, then they'll certainly do that. There's also examples here of to keep in mind of certain flow downs with alteration. And so you commonly see this again as we have that list of the various clauses that are flowed down here, the 180 different clauses. I commonly see this where a prime contractor will include those 5 pages as Exhibit A and say these all flow down. Okay, but are we actually thinking through what's the impact of that flow down? Because incorporating a clause without modifying that clause can create confusion. For example, the 52233-1 disputes clause. Dumb example, but I stumbled upon this case a number of years ago about 2 companies. They were second and third down in the supply chain, and they got into a dispute. Third tier subcontractor wrote something, submitted a claim up to the second tier subcontractor, claiming increased contract costs. And the second tier subcontractor, just giving them the business, right? They said, our subcontract actually flows down FAR 52233-1. And guess what, third tier subcontractor? Since it was flowed down to you, your disputes obligation is you need to submit something up to the contracting officer, because that's what the clause says. Third tier says, what are you talking about? That's stupid. They don't even know that I exist. And second tier, of course, in an attempt to stall this out, shrugs its shoulders and says, well, sorry, it is what the contract says, and we flowed this down without alterations, and there you go. So this thing led to litigation as the parties were figuring out what kind of disputes process they needed to go through. The trial court ultimately said, yeah, look, the contract says what it says. You have to submit this. It went up on appeal, and the U.S. Court of Appeals basically said, that's stupid. Like the government contracting officer does not even know that third tier exists. They don't know who they are, and they certainly won't entertain a claim from them, and we're not going to make them do pointless things. We know what's going on here. We know that second tier is just trying to stall this out, and it's not well taken. But nonetheless, we recognize that you have a little bit of sloppy built into your contract because of how you flowed this down. So to me, it's a good reminder that some of these clauses, as you're flowing them down, you want to make sure that you are appropriately modifying the terms and definitions. And what I normally see on that sometimes is it's an annotation in the prime contract that says we're flowing down the following clauses. And in these clauses, government shall mean prime contractor, contractor shall mean subcontractor, and so on and so forth, to make sure that the parties are appropriately adjusted in this, instead of saying just leaving the clause as is and coming up with the absurd situation where a third tier subcontractor has to submit something directly to the government customer. That's just odd. So anyway, so some of these clauses you're going to want to make sure when you flow them down, you are altering them appropriately to make sure that the contract is clear, but also to make sure that you're not giving the prime contractor more rights than you intend. So the example that we commonly see on this is the termination for convenience clause. The federal government reserves the right to terminate a contract for any reason whatsoever because it's good to be the king. And so this is commonly flowed down where prime contractors say, okay, I'm just flowing this down to you. And so subcontractor, I'm stepping into the shoes of the government, and I reserve the right to terminate our subcontract for any reason whatsoever. The difference on this, though, is the prime contractor isn't the king. At best, the prime contractor here is the knight or the prince, right? Not necessarily the one sitting on the throne, though. And so the idea that they necessarily get a right to terminate for convenience is an assumption that maybe you could push back on. Now, we see lots of companies that don't push back on it. They just shrug their shoulders and they sign it. But what I commonly see on this as well is people say, they push back and say, no, look, Prime, you're a commercial company just like me. We know how this works. I'll tell you what, we'll agree to modifying that clause. We will agree to termination for convenience when the government terminates, right? Because there's nothing you can do to limit the government's rights there. But when it comes to you, Prime, terminating me for convenience, I've got some things I want out of it. I want some contractual language that will let me get my costs back that I've incurred up to this date. I'm going to require 30 days notice, things like that. A prime contractor, a commercial company, doesn't necessarily deserve the right to terminate for its own convenience. That's a little unusual because the prime contractor is different from the U.S. government. So a lot of times I see that flowed down straight through, and that's maybe fine. But what it is, subcontractor, you've given that prime a lot more rights than they might otherwise have. And through the process of negotiation, you might actually be able to trim that in a little bit. And for every subcontractor, I recommend that you have that conversation. Now, the prime might not actually be willing to budge on that. They might say, no, this is what we expect, and take it or leave it. And in that respect, it becomes a question of negotiation leverage. Who has the leverage and can you get something out of it? But I think often you can. And to the credit of most prime contractors, I think many of them are willing to at least have that conversation to recognize that a commercial company subcontracting with a commercial company is different from the U.S. government contracting with a commercial company. So. All right, so that's the idea of kind of risk management, some of the practicalities of Flowdowns. Let me move on to one of the biggest lies in government contracting, and it's this idea of self self-deleting. Okay, what do I mean by this? It's out there. We hear it all the time where people say, "Oh, that clause doesn't apply to you, so it's self-deleting." "Oh, I'm doing supplies, a supply delivery, so all of these services related contracts are self-deleting. So they can stay in and it won't matter." Well, now Dave Gallagher, as your friend, not necessarily your lawyer, but as your friend, my response is, if they don't apply, let's get them out, right? Like, let's just redline them, delete them. And they say, "Oh, but we don't need to actually do that because they're self-deleting because it's a practical matter. They don't apply." To be clear, self-deleting is not a thing. There is no such thing as self-deleting. As long as it's in your contract, it's in your contract. Now, as a practical matter, though, it might help you as a subcontractor assess the relative risk of a clause. So I've got three examples here. I've got 222-41 service contract labor standards. I've got 225-26 private security functions outside the United States, and 226-6, one of my favorites, promoting excess food donation to nonprofit organizations when you are providing catering services. And so you may say, "Dave, I'm delivering supplies. I'm not covered by the service contract labor standards. I'm not providing private security functions, and I'm not a caterer." So the prime would say, "Well, then there's no harm in keeping those in your contract." And they might be right. Like, those are probably three relatively harmless clauses to keep in your contract and that you're not going to have to worry about. But and they'll say, "Oh, they're self-deleting then." But remember, self-deleting is not a thing because these are in your contract. So if push comes to shove, and for whatever reason you expand beyond merely delivering supplies, and now you're also providing private security functions outside the United States, you're covered, right? So my example on this is a number of years ago, I had a client that was doing a smart grid. They were a utility in California, and they're doing smart grid installations. And this was under the 2009 Stimulus Act. Remember that? Those were all the shovel-ready projects, Obama era. And they had built into this a minimum wage, essentially, for construction contracts called the Davis-Bacon Act. And the Davis-Bacon Act essentially sets minimum wage that's going to be paid to construction workers on construction projects. And this was standard boilerplate in all of these things. So my client took some of this Recovery Act money, and they had some of this Davis-Bacon language in it. But the client looked at the government who was awarding this and said, "We're not doing any construction work. Like, we're installing these meters, and that's it." And the government said, "Yeah, you're absolutely right. So it's self-deleting, and there's no harm in keeping it in." Well, so the client came to me and I said, "Well, look, it's in the contract. So, like, what happens next?" And the client looked at it and they're like, "You know what? We're relatively confident that, okay, we're not going to be doing any of that construction work. So that's fine." It helped them assess the relative risk of keeping that clause in and the relative cost of potentially complying with that. And they ultimately concluded it was probably a low price, low cost impact. And they moved on. We used self-deleting as a fiction to get us comfortable while recognizing that it was still in the contract. So flash forward a little bit. Some of the people that were working on these smart grid installations filed a complaint with the Department of Defense, and they came through and said, with the Department of Labor, and Department of Labor said, "Yeah, we actually are going to consider these things as Davis-Bacon Act covered jobs." Even though there's no construction work going on, that's the conclusion Department of Labor reached, and voila. So my client now is left holding a contract with a self-deleting Davis-Bacon thing that now suddenly we have to deal with because it wasn't self-deleting. It was always in the contract. And so we had to kind of deal with the implications of that. It's something that the other side will use to try to get us comfortable with the idea as to why we don't need to remove language. Sometimes the other side will say, "I actually can't remove that." In my case here with this utility client, the Department of Energy contracting officer was too scared to, like, exercise his independent will and kind of redline that out. Because what happens if I get in trouble? And so a lot of times that fear of what happens if I remove the wrong thing kind of overrides this. And what it does, I think, as a functional matter, is it makes the contracts fatter than they need to be. I think it means we have a lot of stuff in there that don't really matter. I wish our contracts could just say exactly what we need. But unfortunately, when you start with a stack that big from the federal government, you're never really getting to an official point of what do we really just need in this. We're flowing down a lot more than we need to. So anyway, bottom line on self-deleting, it's a thing. People use it all the time. But it is not a real thing. It is a palliative that people put out to try to get you more comfortable with the risk of accepting a particular clause. And oftentimes we use it and we say, you know what? I'm delivering widgets. I can take 222-41 and 225-26 and 226-6, and I can keep those in my contract and probably pretty low risk. And there you go. And I would say 9 times out of 10, you're probably right. That low risk doesn't really materialize. But it's that 1 time out of 10 when you're dealing with Davis-Bacon Act doesn't apply. Oh, maybe it does a couple of years later. That's where self-deleting really gets really obnoxious. And I don't know exactly what the solution is on this. I know that there's a lot of companies that flow down an awful lot because they're trying to manage their risk. But imagine, I feel a little bit like quoting John Lennon here, right? Imagine that there's a world out there where, we can all get along and where we're just flowing down exactly what we need to. And we don't have to lie to ourselves that things are self-deleting. I have the courage to remove what I don't actually need, and you have the ability to push back. You may say I'm a dreamer, but I'm not the only one. So maybe someday you'll join us and our contracts can be as one. Okay, off of self-deleting here. Let me move on to this idea here about the Christian doctrine. The Christian doctrine is a principle that basically says in prime contracts, there are certain contract provisions that will be implied as a matter of law into that prime contract, even if it was not specifically spelled out and written in. The case goes back actually to there are some great law review articles. One of them I read was like the Immaculate Conception under the Christian doctrine, which I think is like brilliant and maybe blasphemous simultaneously. But leaving that aside, the reason it's called the Christian doctrine has to do with the original case from about 60 years ago. G.L. Christian and Associates. They were an architect and engineering firm, and they were doing some design work for the government. And during the contract negotiations, they actually redlined out. They got the contracting officer to agree to remove the termination for convenience clause. Boom. They signed it. They go performing. And then after a while, the government decides to terminate for the government's convenience. And Christian says, you can't do that. It's not in the contract. And what the Court of Claims concluded was like, yeah, but it should have been. Like that contracting officer didn't have the authority to redline it out. And specifically, the standard that they articulated was that if there is a particular clause or a rule that reflects a deeply ingrained strand of public procurement policy, then that kind of thing will be incorporated in a prime contract as a matter of law. So Christian, even though, yes, that was deliberately redlined out, deliberately removed, no, sorry, this ability of the government to terminate contracts if and when it needs reflects a deeply ingrained strand of public procurement policy. Therefore, it is implied in your contract as a matter of law, and the government had the right to terminate that clause for convenience. And what it means as a practical matter is that when you're a prime contractor, there is always the risk that if the government omitted a clause that it should have put in there, that clause can magically appear back in your prime contract. And that's a little dangerous, right? That's a little scary because you never know, like you're working on complying with the obligations in the four corners of your contract, but there's always the risk, is there something more out there that I didn't know about that I should have known about? Okay, so for prime contractors, that's an ongoing risk. There's an open debate as to whether the Christian doctrine applies at the subcontract level. And generally speaking, the answer is no, it does not. Why? There's a difference between the government, the sovereign nation contracting with a prime contractor, and a prime contractor, commercial company contracting with a sub. Different policy considerations come into play here in this. And frankly, while not expressly stated too, there's oftentimes a little bit of presumed level of competence, which is not to say that the government contracting officers are incompetent. I'm not saying that. But there's often this idea that they're overworked and maybe they're stretched and not fully trained, as opposed to the prime contract community that is maybe a little bit more up on these things. I don't know that that's necessarily true, but that will often come up as to why the federal government can avail itself of the Christian doctrine and prime contractors shouldn't. What it means as a practical matter is that you need to make sure, I mentioned this earlier, you need to make sure that a clause is specifically called out in your contract, in your subcontract, if it's going to apply. Christian doctrine does not apply to this. And there's a good case that frankly lays out these issues here from 2015 out of Illinois Energy Labs v. Edwards Engineering that really makes clear that no, it doesn't apply to a prime sub relationship. But about 15 years ago, there was a question on this. And what happened was the OFCCP, this is the Office of Federal Contract Compliance Programs, that is part of the Department of Labor that specifically goes through and audits government contractors and their compliance with the Department of Labor equal employment opportunity clauses. They went through and they were trying to audit hospitals down in Florida. And the hospital would delegate or subcontract nearly all of its management work to a subcontractor. So there's a TRICARE award to the hospital. The hospital then subcontracts everything to a management company, and there you go. It feels like they're really the surrogate for the hospital, but when it came through and OCCP wanted to audit them and their compliance with the EEO clauses, these management companies shrugged their shoulders and said, go away. We don't have to listen to you. It's not in our contracts. We redlined all those things out and go away. OFCCP pushed that, and they got some administrative law judges and even a federal district court judge to agree that the principles behind the Christian doctrine are important enough, certainly for these EEO related clauses, that it should apply at the subcontract level. So those were 2009, 2010. Now, procedurally, this played out a little bit. They ended up going up on appeal. And while they were on appeal, Congress passed laws that limited OFCCP's ability to pursue these things. And so it mooted the cases, which means that all the lower cases were all vacated. And so they don't have any legal effect. But nonetheless, there are some of these decisions out there where smart people concluded, yeah, maybe the Christian doctrine should apply. Like I said, I think the better thinking here is in this Energy Labs Edwards Engineering case to lay out why the Christian shouldn't apply to subcontractors. But nonetheless, it's a low risk issue as to whether the Christian doctrine applies at a subcontract level, but it's not a no risk issue. Okay. I'm going to shift gears a little bit here now. I've talked about some of the general principles relating to how you flow these things down, why you flow these things down as a risk management perspective, talked about this fiction of self-deleting, and then talked about this kind of gray area, although not quite so gray, relating to the Christian doctrine. And again, to reiterate, Christian doctrine applies at the prime contract level, not at the subcontract level. That seems to be where things are fairly settled now. But I want to move on now to the list of flowdowns. Okay, and again, I mentioned this earlier, but I kind of put these into three buckets of mandatory flowdowns, necessary flowdowns, and then my others. Because at the end of the day, remember, you need to manage the risk of flowing down what you've promised to do in your prime contract, and maybe those are your mandatory flowdowns, and then also the risk of helping to make sure that your supplier is delivering what you need to meet the customer's requirements. And even though maybe you weren't obligated to flow those things down, you need to. It is necessary to flow those down as a practical matter. So let me kind of walk through each of these buckets here of mandatory, necessary, and other. And again, mandatory, necessary, these are Dave Gallacher buckets I've done to try to help conceptualize this. Certain clauses are mandated by law to flow down. And so here's a few examples on this. Contractor Code of Business Ethics and Conduct, small business opportunities, and if you're a large business with contracts valued over $750,000, you probably have to have a small business subcontracting plan as well. And maybe that's flowed down. You have some of these EEO clauses, implementing socioeconomic policies. You have human trafficking prohibitions. And then, of course, the three most recent that we've been dealing with over the last few years, there's the ban on Chinese-made telecommunications equipment, especially from Huawei and ZTE. There's the TikTok ban that came out last summer, and then newest from right around Christmas time is this federal acquisition supply chain exclusion orders, the requirement to check on a quarterly basis to make sure that your suppliers are not providing products that are banned or from companies that are banned on this. So these are things that the federal government wants to make sure are reaching far down into the supply chain because, again, using the power of the purse, these are important government objectives. Other clauses, as I said, might be included as a practical matter to ensure prime contract compliance, and we'll look at those in a minute. Okay, let me run you through a decision tree here a little bit. The FAR distinguishes between flow downs for commercial versus non-commercial subcontracts. What do I mean by commercial? I mean commercial products or commercial services as those terms are defined in FAR 2.101. And it will usually be apparent to you from the face of your prime contract what you have. Is it a commercial product under or commercial service under FAR Part 12? Or is there no mention of FAR Part 12? If there's a lot of mention of FAR Part 12 in your prime contract, you probably have commercial. So consequently, the next question becomes, okay, what does my subcontract look like? If I have a commercial subcontract, there's specific lists of flow downs that you must flow down. And we'll look at that list in a minute. If you have a non-commercial, all bets are off. So let's start with the worst case scenario here. If you have a non-commercial subcontract, which is what we saw on those slides earlier with those 180 different clauses, and if you have a non-commercial prime contract and then you have a non-commercial subcontract, you are probably going to be flowing down everything but the kitchen sink. I hope you'll be careful on self-deleting things. Let's just move those out like it's going to be okay. And I hope that you are thoughtful and careful as far as how you're flowing those down. But the truth of the matter is, non-commercial prime, non-commercial sub, you're probably getting just about everything out of that prime contract. Now, I would encourage you to be careful as far as how you flow those down. It's a little bit of a sloppy and blunt tool to just say, and here's my prime contract and everything will apply. But sometimes, as a concession of the shortness of life, that's all the time that we have for these things. So that's how we flow it down. But it's always nice when we can know exactly what the specific clauses are because they're listed. Again, listed and either by incorporation or by the express terms on that. Now, you can try to negotiate out from under some of those things, but I'll tell you right now, non-commercial prime that's probably this thick and a non-commercial subcontract, you're probably dealing with just about everything and you don't have a whole lot of leverage there. So keep that in mind. Now, if we're dealing with a non-commercial prime, but you have a commercial subcontract under that, there are two clauses that spell out what the specific mandatory flow downs are. First clause is 52244-6, titled Subcontracts for Commercial Products and Commercial Services. And it lists 23 separate clauses here. Now, you see the three that I've highlighted in red here that are basically the newest ones. So if you live in this space and you think about it, these are probably the three newest ones that have come up in the last several months, including, as I mentioned, 52204-30, the Federal Acquisition Supply Chain Security Act orders and the prohibition on dealing with some of these blocked parties. On that. That came out in December. That's the last change from about 5 months ago. But this is the list. It says you must flow these clauses down. Okay, so start with this list. If I'm a commercial subcontractor, I'm going to start off and say, I'll take these 23 and that's it, unless you can prove it up for me more as to why I need to take more than that. So then you get into a function of negotiation, right? I always tell clients, you might notice that I've lined out through number 2 here, 52203-15. This is listed as a mandatory flow down, but this comes back to that stimulus act from 2009, the Obama era flow downs. These were all the shovel ready projects, and now 15 years later, I think those are all done, right? Right? Maybe? Question mark. So this is something that I think actually is probably self-deleting. You could probably take it with little risk. But if you're the prime contractor, I always tell them, I'm like, this is an easy one that you could probably give up, especially if you're not receiving, if your project is not funded with Recovery Act money in that. So anyway, bottom line, these are the 23 that you probably need to start with. But it's not necessarily just these 23. I said that there were 2 clauses that gave you the lists, and they're not identical. 52212-5E1 goes through and gives you a list of 26 clauses, different from the 23 we just looked at here. These are substantially the same, but not identical. Again, some of the key differences here on this is there are, on this clause, there's references to the service contract labor standards. There's the E-Verify clause, and there you go. So those are the 2 sources to identify your mandatory clauses. I have clients often say to me, why are there 2 lists? And the answer is because the government hates me. I'm sorry. No, I think it's just because the way that 244-6 and 212-5 kind of evolved in the rulemaking process, they came out of 2 different priorities here. You would think that somebody would reconcile the 2, but they haven't. So what most companies do is they just mash them together into a list of the 28 clauses that are common between 244-6 and 212-5E. And I think, frankly, that's probably a good idea. It's simpler to have a single process in place. So you mash that together and you say, commercial subcontractor, I need you to start with these 28 clauses. And if I'm a commercial subcontractor, I'm going to say, fine. I'll take those 28 clauses because I know I probably don't have any choice. These are mandatory flow downs under 244-6 and 212-5E. But anything else than that, prime contractor, you're going to have to bring it on. You're going to have to prove up to me why it needs to be in my contract, why it's a necessary flow down. Now, this arrogance that I'm projecting here seems to contemplate that the subcontractor maybe has more negotiation authority. I think oftentimes what it is prime contractors say, we're going to start with those 28 clauses, take those, and then here's an additional 60 or 70. And I don't know that there's a perfect answer for that other than to say, subcontractors, you do have a little bit of leverage in pushing back on that. I say a little bit of leverage because FAR 244-6C2 says, while not required, the contractor may flow down to subcontracts for commercial products or commercial services a minimal number of additional clauses necessary to satisfy contractual obligations. Define minimal. Is 70 out of 180, is that minimal? Yes? Question mark? I don't know. But so this is where you get into a little bit of a kind of gray area here of what do you actually need to accomplish your objective. And subcontractors, I hope you're able to push back responsibly, but also recognizing that if the prime contractor needs this to accomplish its mission, it might be a deal breaker. Let me give you an example on this. What if I'm a reseller and you're providing me with widgets that I'm delivering up to the government customer, and whatever I'm delivering needs to meet the Buy American Act or Trade Agreements Act. This is a common country of origin provisions in these government contracts. You say it's not a mandatory flow down, Dave. I'm not accepting it. And I say, but you have to, because if you're delivering products made from China up to the federal government, there's going to be a problem with that. And yes, this is not listed on 244-6 or 212-5E. But I'll tell you, as a practical matter, this is necessary. And if you tell me no, I'm going to go on and I've got to find another manufacturer here for me to enter into a contract with. So, as a practical matter here, I think that the subs need to be aware of what the prime needs to meet its contract requirements, but the primes also have to recognize that it is easy to push too far when you have a commercial subcontract. So I have here a list of some of these clauses that, in my experience, are frequently considered necessary, and I'm not sure that you have a whole lot of room to push back on these, even though they're not among the 28 clauses listed at 244-6 or under 212-5E. You have the cybersecurity requirements. Now, there is a basic cybersecurity that is included as a mandatory flow down, but if you're dealing with the DFARS clause, 252-204-7012, you probably are going to have to accept that. And the trigger on that is, are you handling controlled, unclassified information? If you are, boom, you're in there. And you're not going to be able to get out from under it. And I'm sorry. I mentioned Buy American country of origin issues. There's other sourcing restrictions relating to like DFARS on sourcing electronic parts to the maximum extent possible, going back and buying those from the OEM, the original equipment manufacturer. There's technical data rights and computer software rights. Those are not listed as mandatory flow downs, but as we saw before, there is a provision in those clauses, especially the DFARS clauses, that says you prime must flow down this clause exactly as written. So if I'm not dealing with data rights, it might not be a problem, but if I am, that's probably a necessary clause. Cost or pricing data and the ability to audit it. Background check, facility access relating to if I'm a subcontractor that's going to be delivering or will need government facility access, guess what? I probably need to accept some of those flow down clauses here, even though they're not listed. I see organizational conflict of interest clauses that are regularly flowed down. I see some of these H clauses. Section H of the contract is the custom requirements for this particular contract, this particular agency. Pay close attention to those because, again, it's unique to this particular prime contractor. So it may very well be a unique requirement that just because it's not included in 244-6 or 212-5E, you may very well have to deal with this. So, look, we've got the list of 28 that I think we start with. But I think we need to be open to the fact that there may be other necessary flow downs that we're going to have to deal with as well. But remember, the language that we saw in 244-6C says minimal. So I hope that we can moderate this, that we can mitigate some of the tendency to just flow down everything, including the kitchen sink, all 180 clauses that we saw earlier. Now, most recently, about 6 months ago, there was a new DFARS clause that came out. And it's at 252-244-7000. And this is the equivalent of what the mandatory flow downs are for the DFARS clauses. And guess what it says? It says the contractor shall not include. So there's actually no list here. Are there no mandatory DFARS flow downs? That's what it says here. The contractor shall not include the terms of any FAR or DFARS clause in subcontracts for commercial products or commercial services at any tier unless it's listed in 244-6 and 212-5E. So we've gone through those 28 clauses. It's listed in a particular clause. And then, of course, there's, as a practical matter, some of these necessary flow downs that we have to consider, right? Now, I'm not really sure what specified in a particular clause means. Does that mean that it's something like I think of like the Anti-Kickback Act, right? It says in that clause you should flow this down, but it's not listed in 244-6 or 212-5E. Does that mean I must flow it down to a commercial subcontract? I don't completely know. And I don't know, frankly, that industry knows. Look, you have big boys like Boeing and Lockheed that are just pushing everything through. And maybe over the last 6 months, they're rethinking as to whether or not they push too much. But, and I think that that's frankly maybe one of the biggest takeaways. There's a lot of people, I've read a lot of stuff on this new 244-7000 clause that are like, oh my gosh, contractors are now going to get in trouble if they flow down too much. I don't know that that's true. I'm not sure that there's any clear consequences if a prime contractor flows down too many clauses, especially if, as a practical matter, we need to get those flowed down, right, to meet the government requirements. So anyway, I think where this leaves us here, as far as this new DFARS clause, is prime contractors are, I think, trying to be a little bit more cautious. But the idea that you're going to get your commercial subcontract to only those 28 clauses and nothing more of those mandatory flowdowns, I don't think that's realistic. I think you're going to continue to get the mandatory clauses. You're going to continue to get the necessary clauses, and it might be a longer list than you like. But I invite subcontractors to push back, right? Because technically, if it's not required, push back on some of these self-deleting clauses, right? Maybe that's one of the great things that this new DFARS clause will do, is it will let us face this abomination that is self-deleting, this fiction that we do to help us sleep better at night. As I flow stuff down, I flow down on my risk, and when I receive it, I say, well, it feels like it's mostly self-deleting. As a practical matter, I think with this new DFARS rule, your non-commercial subcontracts, you're going to continue to get the kitchen sink approach. And with commercial subcontracts, there'll probably be something a little bit more tailored. And we'll see how that continues to fall out there. But I do not think it is right to read 244-7000 as a limit, saying only those 28 clauses and nothing more. I think that goes too far, because it puts the prime contractor and, frankly, the government customer in a position where they might not be able to get done what they need to get done. All right, well, here's some questions here, and I think I've answered these. What if the clause says you must flow it down, but it's not listed? I don't know. I think, it becomes a question of, is it still nonetheless necessary? If it's not necessary, I hope we can get it out. What if the version of the clause is undated? Again, we talked about that. How far down in the supply chain do these flow downs need to go? The government would prefer if it's all the way down. But look, here's the thing. If I'm a reseller, let's say I'm an office supply reseller, and I am selling directly to the government, and I have mandatory flow downs, and I'm getting materials from 3M, I'm getting Post-it notes. Is it realistic to think that David Gallacher Office Supply Inc., a subsidiary of Dunder Mifflin and Sabre Corp., that I am that guy? Can I really force 3M to accept my flowdown clauses? And I think the answer is no. And so maybe I try and we do the best we can, but I think the government recognizes that at the end of the day, you can only do so much. And the government would love it if I forced that on 3M, and 3M forced it down through their entire supply chain, right? But that's not going to happen. There is a point where these flowdowns drop off. So try the best you can, especially if it's necessary for you, if it's a mandatory for you, try to make sure that that's in there. And there you go. And as far as negotiating some of these things out, it all depends on who has the leverage. Okay, just about done, and then we're going to jump into our quiz here. There's also other flowdowns on this, and what I see on this, I see this fairly commonly. These are standard terms and conditions that substitute for flowdown clauses. So, and what I mean by this is, for instance, I used termination for convenience, right? Before, I see sometimes people flow it down, but what I see more commonly is David Gallacher Inc. Prime Contractor has my own custom termination for convenience clause. And I'm flowing that down through my standard terms and conditions. So I'm flowing it down in principle, but not necessarily in fact. So there's no reference to the, what is it? I think it's 249-1 clause. There's no reference to that expressly, but I'm still implementing this through some kind of, I'm flowing down the principle, if not the actual clause itself. So I see this often with termination, default, excusable delay, liquidated damages. The list is on here, but where these are things that are in the prime contract, but as a practical matter, the prime contractor says, I don't want to flow this down exactly. I want to tailor it to my specific needs as part of my standard terms and conditions. So yes, I have a prime contract with default and disputes processes and a changes clause and audit provisions. But rather than flow down a particular numbered clause, I'm going to flow down whatever it is that I require. This is custom language that I'm using to accomplish my needs here. And I think that's actually probably a better way to do it. Just flowing down all these clauses is a blunt tool, and it can get a little sloppy. To the extent you are tailoring these things so you're accomplishing the purpose, but also specifically what your company is trying to accomplish here, as opposed to just flowing through whatever the government is trying to accomplish. I think that's a better way of doing these things. So bottom line on this, I think you have mandatory flow down clauses, you have necessary flow down clauses, and then what I call other flow down clauses. And these are things that you are flowing down in idea or in principle, but you're really tailoring them so they are unique to your specific prime contractor terms and conditions. And there you go. And again, at that point, subcontractor, you're in the same positions with any contract. It's a matter of negotiations. Maybe you can get some of those out, maybe you can't. All right, we've had a lot of questions come in. Excited for this. Let me get through here, though, into quiz recap. Joshua, you want to read these or you want me to?
Either or,
I'll
I can go ahead and read it.
Okay, you go ahead.
Question number 1. Why do prime contractors typically flow down so many subcontract requirements? A, because they are lazy. B, because the prime contract with the government requires them to flow down every single clause, even to commercial subcontracts. C, because they are trying to manage their contract risk. Or D, because they will be suspended or debarred if they do not.
All
I'll
right,
give you
so
guys a
let's throw
second
up
to
that
read.
poll. What do you guys think? Is it A, lazy, B, the government requires them to flow everything down? Is it C, they're trying to manage their risk, or D, they'll be suspended or debarred otherwise? What do you guys think? We get lazy. We get government requirements. Nobody's going for suspension or debarment. Okay, we'll give it about 5 more seconds. All right, looking good. Most of you answered C, and yeah, that's my right answer here that we've got here. It's mainly to manage contract risk. Now, I realize that the lazy aspect, that's a little cheeky. A lot of you guys might answer that and they're like, that's exactly what's going on. It might be right, but let me just recharacterize it. It's not necessarily lazy. We're trying to create a process here that works, right? And if you have 5,000 subcontracts that you're awarding, making sure that you're tailoring every single contract here is maybe unworkable here. So while the process of the prime contractor flowing down everything often maybe feels abusive and lazy, there's a reason for this. Admittedly, many prime contractors overflow their flow down clauses, but these companies are usually trying to manage their risk under the prime contract, ensuring that the government customer gets exactly what it needs, and that certain clauses required to be flowed down in the prime contract are included in the subcontract. If a prime contractor does not flow down a necessary clause, then the company will probably not be suspended or debarred because it could be deemed to have breached its prime contract obligations, and it could be forced to update policies and procedures to meet the government's requirements. So I've never seen companies get into too much hot water for not flowing things down, but normally it's the government saying you need to do better. All right, good job on that. Question number 2, Joshua Lee, this is a true false.
R52.225-26, contractors performing private security functions outside the United States is a, quote, self-deleting clause if you are not performing private security functions outside the United States. A, true. B, false. I've never seen the clause anyway, so it doesn't really matter.
All right, so let's throw that up. What do you think? Is that true? Is this self-deleting? No, it's false. Or, of course, the cheeky answer, I've never seen this clause. And here's the truth. You've seen it. You just maybe haven't paid attention to it because it's in your contracts. You see this all the time because it's one of the 244-6 mandatory flow downs. So there you go. All right, I think we've got most people. We'll give it 5, 4, 3, 2, 1. Okay, Joshua, you want to close that? Thank you. Most of you answered B, false, and that is correct. Remember, there is no such thing as self-deleting. If FAR 52.225-26 is included in your subcontract, then you could be required to comply. Still, as a practical matter, if you're not performing private security functions outside the United States, the risk of being impacted by this clause is probably low, but please remember, low is not zero. Here you go. Okay, question number 3. Joshua, number 3, another true false.
Based on current authority, the Christian doctrine does not pose a substantial risk of FAR and DFAR requirements being implied in your subcontract as a matter of law.
All right, is that A, true, B, false, or C, the cheeky answer? I believe in separation of church and state, David. And you can believe that, but spoiler alert, that's not the right answer for this particular poll. So what do you think? Is that a true or a false statement? Does the Christian doctrine apply? Is there a substantial risk of FAR and DFAR's clauses being implied in your subcontract as a matter of law? We'll give this about 5 more seconds. 5, 4, 3, 2, 1. All right, let's close it. The answer is true. The Christian doctrine does not pose a substantial risk of FAR and DFAR's requirements being implied in your subcontract. The Christian doctrine is a principle that applies at the prime contract level when the government accidentally omits a contract requirement reflecting a deeply ingrained strand of public procurement policy. A subcontract between two commercial companies does not raise the same type of legal concerns, and current authorities reject the idea that the Christian doctrine should apply at the subcontract level. While there were some Department of Labor decisions from 15 years ago that I talked about that held differently, those decisions were ultimately rejected, and they are not controlling authority. So Christian doctrine, prime contract level only, not subcontracts. All right, Joshua, number 4.
Which of these is not a mandatory flowdown under FAR 52.244-6 or 52.212-5E for commercial subcontracts?
Yeah, you don't have to read through them, but
A.
is it
Okay.
contractor code of business ethics and conduct? Is it prohibition on ByteDance? That's the anti-TikTok ban. Is it the E-Verify under 222-54, or is it 249-2 termination for convenience? Or is it E, none of the above? All of these are listed there as mandatory flowdowns. Let's see what you think on this. Most of you are answering D. Let's see here. Next up is E, none of the above. Let's give it 5 more seconds. 5, 4, 3, 2, 1. Let's close it out. Okay, the right answer here is D. Termination for convenience. FAR 52.249-2 is not listed as a mandatory flowdown in commercial subcontracts, while the other 3 clauses are. And I realize it might not be completely fair when there's 20 plus clauses in here to kind of go back and flip through, but anyway, you'll know, and you have the materials here for us. While now, for those of you who said none of the above, remember 249-2 is not listed there. It's probably a good idea for a prime contractor to include some kind of a termination for convenience clause in its subcontracts because it's in your prime contract and you need to manage that risk. But nonetheless, 249-2 is not listed as a mandatory flowdown. Most government contractors typically flow down the clause with modification as a necessary flowdown, or they include some kind of an other tailored termination clause in their standard terms and conditions. All right, last question here on the quiz, and then we'll turn to the other questions here. Joshua, number 5.
Which of the following could represent a necessary flowdown requirement that a prime contractor needs to include in its subcontract to meet the prime contract requirements? A. Cybersecurity. B. Country of origin. C. Technical data rights or computer software rights. D. Organizational conflicts of interest. Or E. All of the above.
All right, so let's put up that poll. What do you guys think? Which of those feels necessary to you? Is it all of the above? And let me be clear on this. there's no list of what's necessary. It's really driven by the specific contract needs of that particular prime contractor and the government customer. Let's close this in 5, 4, 3, 2, 1. Looks like most of you answered E, all of the above. And that's the right answer here. Now, for everybody who said, cybersecurity, country of origin, or technical data rights, those aren't wrong. And again, you might say, you know what, these are the ones that I'm most worried about as far as my necessary flow downs. But I think that in my experience, these are types of clauses that I see. None of these are listed in FAR 52244-6 or 52212-5E as mandatory flow downs. But nonetheless, if it's important to the government customer and the prime contractor that the subcontractor meet these kinds of specific requirements, then the clause may be considered a necessary flow down, whether under a commercial or a non-commercial subcontract. While the government encourages companies to limit the number of flow downs in subcontracts, there is no real consequence if a prime contractor fails to comply. And whether the subcontractor must accept the clause or not is a matter of negotiation. So I think we're at the end. Joshua Lee, we are just about out of time. I'm going to stay on, though, and answer questions. And so if anybody would like, but in the interest of keeping mostly on schedule, Joshua Lee, can you put up the final rate this course? And then I'll come back. I'll queue up the questions here and scroll through these.
I sure can. For those of you who need to hop off, as always, we'd love to know how we did today. All feedback is greatly appreciated. If you guys have any questions, feel free to send them in now. We will be covering questions in just a moment. If not, I thank you all so much for joining in today. We hope to see you all at the next GovCon 101. Make sure you guys check out PCI's website for our upcoming programs.
All right, so my first question I got here is from Samantha. She says, I constantly get the self-deleting response from prime contractors. How can I negotiate that out, as they seem to be taking a harder stance of not removing clauses that are not applicable to my organization? Samantha, I can't give you a perfect answer for this, other than I would note that when you, if you've got the leverage, use it. But at the end of the day, they're flowing it down to try to manage their risk. And that actually might be flowing down clauses that aren't even covered in the interest of just having a simpler process for them. So I don't have a perfect answer for that, but I would encourage you to, as it comes up, you might point to that new DFARS clause and say, look, DFARS is saying you shouldn't be flowing all these things down. You guys need to back up on this. That might be a little bit of a rap on the knuckles to get them to calm down a little bit. Tracy says, any comments regarding the published final rule the DoD is implementing in 244-7000 to state that the contractor shall not use? And I think my answer to that is yes. I think I've talked about that at length. Tracy, I think it's a good way for subcontractors to push back. But most importantly and most clearly, I don't know that if a prime contractor continues to overflow down, that there's any real consequence to this. So please keep that in mind. I think that this is a little bit of a break, but I don't think that it's a hard break for folks. Deseret says, is there a complete list compiled of all the clauses under the Christian doctrine from over the years? Yes, I think there is, Deseret. I don't think that I've seen it in like law review articles. If you Google it, there are law review articles that will routinely pull this up. But I have not, and maybe I should have included it here in that. But it includes things like termination for convenience. It includes, I think, the disputes clause. I think Buy American. I think there's a government property that's been included in that. It's in the neighborhood of about 10 or 15 different clauses. It's not a long list, but that's probably the best way. Google Christian doctrine, which clauses, and that'll probably get you there pretty well. Laura says, what happens if the government is making multiple awards and are unwilling to tailor the contract for a small business versus a large business? The answer is they don't care. Like, and I'm sorry, like they say they pretend to care, but they don't really care. And then she continues, they agree during negotiations that certain clauses do not apply to the small business. Is that negotiation correspondence enough, or would that correspondence need to be incorporated by reference in some way? The answer is it needs to be in your contract. My client that had the Davis-Bacon Act problem, where we got in writing an email that says, yeah, you're right, Davis-Bacon Act doesn't apply, but let's keep it in anyway. We had that in email, but at the end of the day, if that clause applies as a matter of law and it's in your contract, you're going to be covered by it. So I view self-deleting as a little bit of a refuge of the coward, right? I don't have the courage to get it out myself, so I leave it in so that you have to deal with the risk on it. And Laura, I'm sorry about that. And that's the way I think a lot of, in my experience, a lot of these government contractors have, because they don't want the OIG to come on them and say you did it wrong. So if it's in your contract, there's a chance that you might have to deal with it. The question is it a high risk? Is it a high risk? And you're going to have to, assess that based on your own. And that self-deleting cold comfort will often be where people turn to. Sandra says, if my prime contract does not contain a legally mandated clause such as the TikTok, how does that impact my subs? The answer is TikTok may very well be, I'm not aware of any case law on this, but I think there's risk that TikTok could be incorporated as a matter of law into your prime contract. And that would mean that if it is, and you're going to find this out 9 months from now, then it would need to be a mandatory flow down. So I think that the best practice is that most companies do is they take the list, that mashup list of 244-6 and 212-5E, where the TikTok clause is listed, and you load all those in, and you're just as a regular basis flowing that in. I think that's probably the best way. And again, people would say, well, but I'm not doing private security functions. I'm not doing catering. And you say they're self-deleting. And I'm sorry, look, I'm only trying to give you 28 clauses here. Work with me, right? I'm not trying to flow down all the other stuff. And I think most companies kind of recognize that, okay, that's probably as a practical matter, maybe the best we're going to get. And then Laura says, what's the best source or way to know or keep up with the mandatory clauses? What I do is I sign up for Federal Register notices. And so I get an email every morning that says when they've updated or when they're issuing new rules on this. You can set up Google alerts. I have Google alerts on FAR updates that will keep me posted on this. And then every now and then I just log in to to regulations.gov, and I'll just check it up and refresh it. But I don't know, like I try to talk about it a lot, and I'll blog on it and things like that. But the government, I think, doesn't normally make a big deal of it. They just go through the normal process as they do through these things. Okay, so I think that answers all the questions that came in. The big one that I mentioned here, and this might be the last one. This came from Cynthia. She says, and I think we've answered all of these, Cynthia, but if not, let me know. She says, I'm in the process of putting together a commercial contract under a government prime contract. The prime contract is not a commercial contract. The value of the commercial subcontract is $2 million. So, okay, so non-commercial prime, commercial sub, over $2 million. You're starting with your list at 244-6. Maybe you bring in some of those other clauses from 212-5E, but probably at the very least, you're starting with your 23 or so clauses at 212 or 244-6. But as a practical matter, you're over the TINA threshold, over the certified cost of pricing threshold. So in addition to your mandatory, I'll tell you, you have other necessary clauses, including some of these cost of pricing, that you're going to want to make sure you're flowing down. You continue, you say, look, I'm trying to figure out where I start. 212-5, 244-6, yes, start there. And she says, but wait, 244-7000 is in my prime contract. Does that throttle me back a little bit? And my answer is, it should throttle you a little bit, but not a lot of it, because if you have some of these requirements, such as cost or pricing data, you're going to want to make sure you include those. So she says, I'm trying to determine which commercial flowdowns are mandatory to be included in the subcontract. I think I've given you that list. I have the clauses from 212-5 as a starter. I would encourage you mash that up with 244-6. And then there's other clauses in the FAR that need to be flowed down if FAR Part 12 for commercial products and services is used, but this doesn't apply in my situation. Yeah, I would say that you're mostly starting at 244-6. draw on that 212-5E list as well, and then just go through your contract and figure out what else, as a practical matter, do I need to flow down here. What is necessary here for it? She says, any help you can give me, I'd appreciate it. This is the first time I've really gotten into this big of a subcontract off of this big of a prime contract. I wish you luck, Cynthia. I hope this is helpful. If you want to reach out, here's my contact information, and I'm happy to try to help however I can. Let's see here. One last question, I guess. This is Sandra. She says, "Oh, David, I'm sorry. Please repeat your question to my TikTok. There's so much background noise I couldn't hear you. Sounds like dishes being stacked. I'm sorry, whoever was off mute there. There is a chance, and I would consider it more probable than not, that TikTok would be implied in your contract as a matter of law. So I think there's a good chance it could be christened in. I'm not aware of any case law on this point. If it's going to be christened in, then it would be a mandatory flow down for you, even though it's not in your prime contract to flow down. So I think that probably the good best practice for you when you're awarding subcontracts is, regardless of whatever your primes say, you probably want to be starting with those 28 or so mandatory flowdowns under 244-6 and 212-5E. Start with those, and that's probably going to be flowing down this as a practical matter. But keep in mind, this is a little bit of a tension point. You could have an old contract that doesn't have the TikTok clause because it wasn't awarded at the time, and that's right. The government should not necessarily be unilaterally adding those requirements, but they do. They do it all the time, especially on the GSA schedules. So even if it's not in your contract today, there's probably a pretty good chance that it will be refreshed in there. So I think probably best practice on that is start flowing that clause down now, sooner rather than later. All right, Sandra says it is an old contract. Yeah, see? But I'll tell you, the government, I see this all the time, and it annoys me because they're not supposed to do it, but they're trying to advance this policy of just flowing down everything. So anyway, any other questions? I know I've ran like 10 minutes over, and I'm sorry for that. I hope it's helpful, though. If you guys have questions, feel free to send me an email or give me a call. Happy to help however I can. I'll give it a minute or two more. Josh Lee, any last parting words?
Nope, I think we are good to go. If you guys have any final questions, please let us know. We're more than happy to follow up. And if not, I wish everyone a wonderful afternoon. Thank you so much, David.
Thank you, everybody. Be good and good luck with your flowdowns.